judicial employees?
Well, the Code of Conduct sets out pretty firm guidelines for the kinds of political activities that employees can and can't engage in. And there are really two key issues that it addresses. First of all, of course, is what is the form of activity that the employee wants to engage in? And secondly, who is the employee? Because there are different standards for differing employees. In terms of the activities, the most essential question is whether the employee wants to engage in partisan or nonpartisan activities. And unfortunately, the code doesn't define what the difference is between those, but most likely you would look to the definition that's used in the Hatch Act, which is that a partisan activity or a partisan election is one in which someone who's running for office is somehow affiliated with a political party. And that would, of course, extend to the presidential election that we're right in the midst of, but it would probably not cover a lot of local elections like school board and sometimes town council elections, which often are nonpartisan because no one in the election is permitted to be affiliated with a particular political party.
Marilyn, is there anything new for 2000?
Well, 2000, of course, is a presidential election year, and that brings with it primaries and intensive campaigning and so forth. And one issue that has come up frequently because of that is what employees can do in terms of participating in primaries. Of course, we're pretty much past the primary season, but the concern about primaries highlights an issue relating to public endorsements. The concern is that employees might involve themselves in primaries in a way that communicates a public endorsement that they shouldn't be giving to a partisan candidate. But our advice is be wary of any participation in a primary or any other kind of activity that conveys a public endorsement.
What can court employees do or not do in partisan activities?
Probably in the area of partisan activities, the list is a lot longer of what they can't do. The prime concerns are, they're spelled out in the canons, in the Code of Conduct, and they include things like actively campaigning for someone, publicly endorsing a candidate or a party, running for office. Employees should not be running for partisan political office if they're also serving in the federal judiciary. Another big area is money. Anything having to do with money in political campaigns can be problematic, and that means that not only should employees not be soliciting funds if they have a neighbor or friend who's running for office, they shouldn't be engaging in campaign solicitations, but they also shouldn't be contributing, and that sometimes is a surprise to employees. They're not aware of that limitation, and the limitation extends not only to a candidate but to a political party as well.
What about the limitations for nonpartisan activities?
Well, nonpartisan activities are more broadly permitted. Employees can engage, well, let me make one little exception to that, and that is there are certain employee groups, as I mentioned earlier, who are treated differently. And in the area of nonpartisan political activities, employees who are in either court unit executives or are members of a judge's personal staff, chamber staff, those employees should not be engaging in either nonpartisan or partisan political activities. But other employees generally are permitted to engage in nonpartisan political activities, and it's not completely unrestricted, but it does permit them to do the kinds of things they couldn't do in the partisan sector. They can run for office, they can manage someone's campaign, they can endorse or give speeches for candidates in a nonpartisan sector. The restrictions, the prime restrictions, are really on things that relate to their government duties. And so, for example, they of course shouldn't be politicking or campaigning in the office, in the workplace, and they certainly should not be using any federal resources to assist in the effort.
What happens if your spouse is running for political office or a family member? What are the guidelines in this case?
That's a tough question. It undoubtedly comes up all the time. It certainly comes up for judges as well. The basic guideline I would suggest is that the Code of Conduct doesn't purport to tell spouses what to do, but it does tell judicial employees what to do. And the key for the judicial employee who is in that situation is to disassociate himself or herself as much as possible from the spouse's activities. Now, that doesn't mean that they can't appear in a campaign photo, for example, if there's a family photo. But if they're in that photo, they probably shouldn't be listing themselves as law clerk to Judge so-and-so or clerk of court or whatever. So those kinds of restrictions are key. They also, the employee, of course, has the same restrictions that apply in any circumstance. And so if the spouse is running for a partisan office, the employee is going to be much more restricted in the kinds of assistance that can be provided.
What about guidelines for specific groups of judicial employees? You had alluded earlier that chamber staff have some limitations. What about clerks of court or other court unit executives?
Court unit executives are treated as chambers and personal staff are, and that is they are prohibited both from partisan and from nonpartisan activities. What that means in practice is where maybe a deputy clerk could run for the local school board, the clerk of court probably should not, in fact pretty clearly should not be running, even if it's a nonpartisan office in a school board. There's one other special group I want to mention, and that is federal public defender employees. The advice I've been describing so far relates primarily to employees throughout the court system other than federal public defender employees, because federal public defender employees have their own code of conduct, and that code is actually the most permissive in the federal judiciary. It does permit some involvement in partisan political activities as well as nonpartisan. So if there are any federal public defender employees listening, they should be aware that they need to check out separately what their obligations are.
What are the questions that you are asked the most often?
Well, I'd say there are probably a couple. One very frequent question is, why is it that my colleague who works for the executive branch gets to engage in all of these political activities and you're telling me that I can't? And the short answer to that is that the Hatch Act, which applies to the executive branch and was liberalized 4 or 5 years ago, permits executive branch employees to do more than judicial branch employees are permitted to do. The reason being the Hatch Act doesn't apply to the judiciary, never has applied to the judiciary. We generally follow the earlier version of the Hatch Act, which was more restrictive, and the judiciary has decided to maintain those restrictions to keep its employees away from the difficulties and the problems that could be presented by political activities. Another question I get fairly frequently is employees understand that they can't make political contributions, but when it's a good friend who's running, or maybe a spouse or sibling who's running, or maybe the campaign or the election is somewhere all the way across the country, they want to know why they can't do that. And the answer is the rule doesn't differ. It doesn't matter if it's a family member, it doesn't matter how far away it is from your courthouse. The rule is the same. You should not be involving yourself in political activities.
Is there any last piece of advice you'd like to give to court employees out there watching Court to Court today?
A rule of thumb I like to offer is, when in doubt, check it out. There are numerous ways in which employees can be guided, can read about the permissible and impermissible political activities that they may be considering. Probably the most important are the codes of conduct I mentioned earlier. The Code of Conduct for Judicial Employees, Canon 5 covers all the political activities issues we've been discussing, and of course there's a separate Code of Conduct for federal public defenders. There's also a published advisory opinion that contains more detailed advice that I think is quite useful.
And where would we find these, Marilyn?
The materials are all published in the Guide to Judiciary Policies and Procedures, which most courts have available in their libraries. In addition, it's available on the JNet, and it's also available, to the extent people have access to it, it's on Westlaw in a database called Conduct.
Okay. Well, Marilyn, I think you've given court staff some very good advice and guidance today, and we thank you for joining us.
Thank you.
The Federal Judicial Center makes available a Code of Conduct training program. There are now more than 80 people throughout the courts who can make presentations to your court unit. Early last year, another FJC colleague, Bob Luke, asked court training specialists about improvements they wanted in the TR2 training record system. Once the results were in, Bob worked with John Seal, Information Systems Analyst at the Southern District of California Bankruptcy Court in San Diego. John had designed the original software in 1994 and was committed to updating it.
The needs we wanted to address in the new version were primarily to make it more user-friendly. Of course, it had to be Y2K compliant, more flexibility in the reporting, ability to track costs by breaking them out into different categories. The data from the TR2000 can be used with other Windows programs.
To update this program, John worked with the FJC and many court training specialists. One of them, Ann Ross, in the District Court of the Western District of Oklahoma, had tested commercially available packages.
And they're quite costly. You know, they would have cost at least $1,000, $500 to $1,000 for us to purchase one seat of a software package. So with John developing this and making it available to the courts, you know, it was wonderful. It didn't cost us anything.
Dana Muniz from the Bankruptcy Court in the Southern District of Florida is a big believer in the TR2000 software.
I think the TR2000 is it's a great program. What I really like about it is the additional room that has been made available to key in more characters. That in the past, if the title was a long title like post-confirmation matters, we would have to cut it down to post-conf MAT. Now we can actually put the entire title.
John Seal's work, above and beyond his regular job duties, made the TR2000 useful for more than simply tracking hours of training.
There are things in there that could be used by court management, budgeting, and how much staff time has been dedicated to training. You can run some trend analysis and see what types of training is being done.
This direct access is a big plus, says Debbie Lewis of Florida Southern's Bankruptcy Court.
We use it now to let our supervisors access their direct reports, staff's reports. The supervisors do not have to go through someone to get access. When they need the information, they can immediately go to their computers and pull up whatever staff's reports they want. I think John did a fantastic job.
We think the software is so good you'll want to download a copy of TR2000 for your court. But you'll need some patience to take down this DCN address, so bear with me here. It's ftp:/156.131.50.189/TR2000. For the main installation file, download tr2k.exe. And the documentation in PDF format is at trdocs.exe. For a copy of the installation guide and a tutorial and user guide, please call Yvonne Brown here at the center at 202-502-4132.
Still ahead on Court to Court, Bob Fagan will take us on location to find out what streaming really means. And we'll learn more about how personal style affects communication. But first, watch this.
Substance abuse issues play a major part in supervising defendants and offenders. Now, probation and pretrial services officers can get the latest information directly from national experts.
This is among the most complex phenomena facing our society today.
Live on the FJTN, the Federal Judicial Center presents Substance Abuse, a continuing education series which brings you the latest on research, policy, and strategies. Check the FJTN Bulletin or the JNet for air dates of the next edition of this provocative series.
I'm an evaluation form. You've surely seen me before. Well, I'm part of your materials and I perform a vital chore. Well, the information in me helps the center to take stock. It helps them make their programs work to help you do your job. Please fill me in. Please fill me in. Oh, we need this information. Please fill me in. Please fill me in. Oh, we need to know the score. Please fill me in. Please fill me in. Your feedback is important. And if you don't complete this form, we'll sing this song again.
Your feedback is important. Please fill in the evaluation form available in your program materials or online.
The rapid growth of technology in the workplace has meant that we're bombarded with more and more jargon. We can only assume that our predecessors in the 19th century felt the same way when telephones were brought into their offices. Here, with an idyllic take on more words to know, is Bob Fagan.
Ah, the great outdoors and the joy of a rushing stream. It curves and winds, sometimes changes size and shape, but moves continuously. Nowadays, we hear a lot about a different type of stream, streaming video. Streaming video is a sequence of images that are sent over the internet, and at the same moment they arrive at your computer, are displayed on the screen as a steady and uninterrupted flow of media. Most often, the media are video and sound. With the growth of the internet, more and more multimedia files are available. Many of us don't have a fast enough modem or the bandwidth to quickly download the large file of a video clip. You remember bandwidth, don't you, from a previous Words to Know? With streaming, when you click on a link in a web browser, a software application in your computer begins to download the files from the website. But instead of waiting for the whole video to download, the streaming software starts playing the video as soon as the first seconds of it come across the link. And even as the video plays on your screen, the streaming software continues to download more sections of the video into a background buffer in your computer's RAM or memory. Think of a conveyor belt moving the data from the source to your screen. The conveyor belt is the RAM in your computer, and it holds the preloaded data even as it moves data to your screen. And as soon as the data, the image, has appeared on your screen, the data are dumped from your computer. This is great news for those of us always in a hurry, especially when some videos might take hours to download entirely. But streaming isn't perfect. The image is often degraded and the motion jerky. That's because the streaming software drops some of the video frames in order to keep playing the images continuously, without interruption. The software adjusts to the rate that a system can handle the data, and the rate is dependent on your system's bandwidth. Which brings us to ISDN. It stands for Integrated Services Digital Network. These lines carry data, voice, or video digitally from end to end. Traditionally, our digital computers have been connected to the internet and other computers by means of ordinary analog telephone lines. They transmit at much slower speeds. ISDN service can transmit at the rate of 128 kilobytes per second, doubling the rate of analog phone lines. Phone companies charge a higher monthly rate for ISDN lines than for traditional phone lines. Courts can use the increased transmission speed of ISDN for video conferencing with other courts and for faster communication with divisional offices. There are even higher speed lines, such as T1s, T3s, and DSL, all of which are more expensive still. But as we need to move more information faster with higher quality, we'll be using them more and more. Two courts that are already using higher speed lines and streaming video of FJTN programming on individual desktops are district courts in Nebraska and Alabama Southern. That's Words to Know for today. I'm going to hike on out of here, and I'll see you on a future Court to Court. I just hope they don't put me on the information superhighway.
In another part of the electronic world, the Federal Judicial Center has made available a computer-assisted instructional program on the federal rules of bankruptcy procedure. This interactive CD-ROM will help bankruptcy deputy clerks learn how the federal rules apply to their work. The CD-ROM gives instant access to the bankruptcy code and rules through an index and a search capacity by word, code, or rule number. But more than that, it's an educational tool with case scenarios and quizzes so that users can learn from seeing the rules in use and testing their own proficiency. These features are part of the section Life of a Bankruptcy Case. The key events in the case are displayed, and users have access to an explanation of each event and to the relevant sections of the code and rules, all at their fingertips. Users can even choose on which bankruptcy chapter they want to focus. It does not appear that any bankruptcy legislation that Congress may enact during the summer of 2000 will render the program out of date, at least in any significant way. Your court unit executive or training coordinator should have a copy of this CD-ROM. Contact them to get it, or call Bob Fagan here at the center at 202-502-5444. 4123. On our last program, we brought you a segment about improving interpersonal communication. Management consultant Joel Freeman had spoken at a bankruptcy court conference and stressed the importance of understanding different styles of communication. Your response to that segment was very positive, and so, backed by popular demand, here's more of Freeman's insights into dealing with people who drive you crazy.
Joel Freeman says that one of the key differences in communication styles is whether someone is oriented toward tasks or people. In his presentation at the Bankruptcy Court Managers Conference, Freeman compared communication style to a car. Some folks go faster and some slower. Sometimes difficulties occur when people with different styles work together.
These folks are going 150 miles per hour toward the task. Ever met someone like that? They cut that thing cranked right over, to the pedal to the metal. And if you work for them, if you work with them, if you are them, it is a challenge. And if you are them, it is important to understand the perception that other people may have of you as an individual. Can you imagine working for someone who's 150 miles per hour toward the task, and you're 55 miles per hour toward people? Can you imagine how the perceptions of each other are? I mean, it's funny. It's crazy. If you're 55, 60 miles per hour toward the task, and you are a person that it takes more time to describe what the job is, so you end up being a person who can't delegate very well because you can do it quicker than it takes time to explain it. And so you end up being a person that's just going around doing everything, and then you get frazzled and you say, I just feel like an automaton.
Difficulties also can occur when people-oriented individuals move faster than those around them.
If you're 150 miles per hour toward people, it's like, too much information. Hi, how are you? You know, just enter a room mouth first. Dominate a meeting. You know, overwhelm people with so much yip yap and talk so much of the time, perhaps, that what happens is that it causes people to shut down.
One part of the people-oriented group are influencers. They are outgoing and intuitive.
All these new bright ideas are just pouring through them, and sometimes they feel like it's a curse. And they just can't seem to turn the tap off because all these ideas are flowing in them constantly. Do they implement them? Rarely. And sometimes when they bring it up, people say, oh, you're the one with the idea, you ought to do it. It's the worst thing you can say to them. Because then they shut down, they don't want to bring their idea up anymore. These individuals, they love achievement and recognition and these types of things. Some of the things that turn them off, are lack of enthusiasm, indifference to their plans, and those types of issues.
Freeman believes that all of us would be wise to understand the styles of those with whom we work.
I find sometimes when you have a very dominant supervisor, for instance, and someone who is more process-oriented, more process people-oriented individual, that individual sometimes gets their feelings hurt. They then sometimes go to the boss 3 or 4 days later, and they say, you don't know how much I've been crying about this or I've been thinking about this, and the boss is going, what are you talking about? I don't understand what planet you're from. What happens is someone who understands this information can begin to say, you know, I am not going to take this personally. I believe this has to do more with the way this individual is wired. So every time I communicate with them, I'm going to communicate them on terms that they understand and are needing to hear.
That's not always easy to do, and it means being attentive to the other person's communication style.
When the thinkers and doers, the task and people-oriented people start working together, you can see the divide developing. And that's why it takes so much effort and so much intentional effort to keep trying to put yourself in the shoes of that other person.
One set of shoes belongs to folks Freeman calls steady.
Many times the clash that develops is steady individuals. These are folks that are looking for the easiest way to get something done, not the quickest way. Now, I hasten to add, these are not lazy people. It's just that these folks look around and they see all these people with the veins popping out of their neck marching toward a coronary heart disease problem. And they say, you know, I like my job, but they don't pay me enough to die early. I am going to superintend my stamina, my time, like a long-distance runner, and I'll pace myself for the long haul.
By long haul, Freeman means a career spanning decades.
So what happens is these folks, the steady individuals, are looking to slow down the pace because you know what? They know one thing. They figured it out early. No one is going to slow the pace down for them. It's always going to be coming in full bore, full pipeline of new things to do next week, the following week, and so you have to kind of set things at a certain pace. And so steady individuals, their key value is they cooperate with others, but they want to make sure that others feel good about the process and feel good about the relationships. They're turned on by closeness and affirmation and kindness. They're turned off by insensitivity and people who push and people who have a hidden agenda and people who use their positions, positional authority. Dominant person says, I want this in my office. I want this report done by 3:30 Friday. That's 2 days from now. I want it done. I want it this thick. I want all the graphs, statistics, everything done. You know what the steady person says? I'll see what we can do. What don't you want me to do in order to get that accomplished?
Among task-oriented individuals, Freeman says, are the correctness folks, who are very analytical.
These are individuals that when they get going, I'll tell you, they are the most incredible, detail-oriented people. In fact, you get in a problem-solving session, and this individual will start the meeting off with Adam and Eve. 4 hours later, they've worked their way up to the Renaissance and describing the history of this particular problem. The ID people are saying, get me out of here. I never want to be in another meeting where this person starts. But this is the gift that they bring. And they bring so much insight and so much information. And these folks, you know what their goal is? It's not the quickest way. It's not the funnest way. It's not the easiest way. It's the hardest way. It is very difficult being an analytical person because no one can be harder on yourself than you yourself. And the whole thing is that they want to be able to promote quality in service. And that's really what drives them. They say, hey, wait a minute, folks. Time out. We're in a meeting here. This eye over here has got a helium balloon filled with the bright ideas. I got a pin behind my back. In 23 seconds, I can ask 2 questions that'll pop that balloon. The eye views the analytical person as a negative, nitpicky person, when really the negative, nitpicky person, as they're perceived by the eye, by the influencer, is really someone that says, hey, folks, hey, listen, before we start investing our time, our energy, and our resources, let's make sure we're going in the right direction. Do we have our ladder up against the right wall? Because if we get to the top and we realize we're against the wrong building or wrong wall, just think of all the waste that's gone on here. So that's really what drives them. When you see the dominant person, what drives them is, folks, we're just paid to work. Let's work and get the job done. Influencers are saying, folks, listen, let's have fun while we're working. Let's enjoy what we're doing. Let's recognize people who have really achieved around here. The steady folks are saying, listen, I just want to make sure that I'm part of an organization where there's genuine relationships developing. The correctness folks, the analytical folks are saying, listen, please, I just want to be a part of an organization that's quality.
Freeman says that all of these folks are part of each organization and that all of them are needed.
I just love to see competent people enhance their interpersonal skills so that they can become more promotable and more valuable to the organization and to themselves.
That's Court to Court for this time. We want to hear your comments about today's program. You can reach us at the Center's website on the Court's intranet on the DCN. Click on Court to Court and then select Online Evaluation. There's also a section where you can tell us topics you'd like to see on future programs. Send the evaluation online or fill one out at your site and mail or fax it to us. Our fax number is 202-502-4088. Be sure to tune in for the next edition of Perspectives on Probation and Pretrial Services, which will feature the recent Chiefs Conference and showcase several detention reduction plans. And I'll be back in the fall with another edition of Court to Court. I'm Michael Burney. On behalf of everyone here at the Federal Judicial Center, thank you for watching today.